Yeah, so the framing of charge under BNSS is a pivotal stage in the criminal proceeding where a court formally accuses a criminal of committing specific offenses based on evidence and allegations that are presented by the prosecution. So prosecution is also the informant. Please make a note /informant. This process plays a crucial role in the criminal justice system by informing the accused of the charges against him. Please underline. By informing the accused of the charges against them. Establishing the legal foundation for the trial and promoting transparency and fairness in the legal proceedings. It is a fundamental aspect of due process, ensuring that the accused's rights are protected and setting up a stage of trial. Please underline the word setting the stage of trial, where the guilt or the innocence is ultimately determined. The framing of charge marks a significant milestone in the journey towards criminal justice system. Now underline section 234. So every charge under this Sanhita shall state offence with which the accused is charged. If the law which creates the offence give it a specific name, then the offence may be described in the charge with that name only. For example, hurt. Assault causing hurt. So you will describe that as assault, and if hurt is also caused, then it will be determined under section hurt, that is 115 subclause 2. So if the law which creates the offence does not give it a specific name, so much of the definition of the offence may be stated as to give the accused notice of the matter for which it is charged. So it must be descriptive, means the accused person must be able to understand, yeah, so this section has been evoked against me for this offense as I have committed this thing. Okay. So the law and the section of charge against the offense is said to be have committed shall be mentioned in the charge. The fact that the charge is made equivalent to the statement that every legal conditions required by the law to constitute the offense charge was fulfilled in a particular case. The charge shall be written in a language of the court. Please underline. So if the language of the court is Hindi, then the charge will be framed in Hindi. If the language of the court is English, then the charge will be framed in English. So if the accused having been previously convicted of an offense is liable by reason of such previous conviction to enhanced punishment, or if the punishment of different kind for subsequent offense, and it is intended to provoke such previous conviction for the purpose of effecting the punishment which the court may think fit to award in the subsequent offense, the fact, date and place of previous conviction shall be stated in the charge, and if such statement has been omitted, the court may add it at any time before the sentence is passed. So last paragraph, last point, please try to understand. For example, if you are previously convicted for an offense, okay, and previously also some punishment you have got from the court, then on charge that must also be mentioned. For example, now you are caught for theft, but before committing theft you also committed once robbery. So when the charge of theft is being framed, the incident about the robbery and the decision about the robbery must also be mentioned. Okay, any doubt? What? Any doubt?
No, ma'am.
Yeah.
No.
Yeah. Then section 235. The charge shall contain such particulars as to the time, place of the alleged offence. Please underline the word time and place of the alleged offence, and the person against whom or the things against whom of it was committed, as are reasonably sufficient to give the accused notice of the matter for which he is charged. So the charge will contain the time and place of the occurrence, the person against whom it was to be given, and the person for which what offense they have committed. Now second point, when the accused is charged with criminal breach of trust or dishonest misappropriation of money or other movable property, it shall be sufficient to specify the gross sum or as the case may be, describe the movable in respect of which the offence is alleged to have been committed, and the dates between which the offence is alleged to have been committed. Please underline the word dates. Without specifying the particular items and exact date, and the charge so framed shall deem to be the charge of one offence with the meaning under section 242, provided that the time between the first and the last of such dates shall not exceed 1 year. So if you have committed 2 offences within a year, then the charge can be from together. Okay.
Ma'am.
Next, section 236. So where the nature of the case is such that the particulars mentioned in section 234 and 235 does not give the accused sufficient notice on the matter for which he is charged, the charge shall also contain the particulars of the manner in which the alleged offence was committed, as will be sufficient for that purpose. Please underline. So if section 234 or 235 information or the charge formation does not give you the exact nature or exact what kind of offence you are committed, then it will be covered under 236. Now 237. In every charge, word used in describing the offence shall deem to have been used in the sense attached to them respectively by the law under such offences punishable. So whatever the definition is given under the sections, those definitions only will be used to correlate the offences committed. Okay. Next is 238. No error in stating either the offence or particulars required to be stated in charge, and no omission to state the offences of those particulars shall be regarded at any stage of the case as material, unless the accused was in fact misled by such error or omission and it was occasioned a failure of justice. So if there is no error shall be stated during the process of argument that there is an error. Okay, all this. Now
Yes, ma'am.
Now section 239. So any court may alter or add charge at any stage before the judgment is pronounced. Please underline. So the court has the power to add or alter charge. So every such alteration or addition shall be read and explained to the accused person. So if the alteration or addition to the charge is such that proceedings immediately with the trial is not likely in the opinion of the court to prejudice the accused in his defense or the prosecutor in the conduct of the case, the court may in its own discretion, after such alteration or addition has been made, proceed with the trial as if it has never been altered. So if the alteration or addition is required, then the court can do that, but after that the court can proceed with the case in the same manner as if no addition or alteration has been made. Okay. So if the alteration or addition is such that the proceedings immediately with the trial is likely in the opinion of the court to prejudice the accused or the prosecution, the court may direct a new trial. Please underline. So if the charge has been altered and if the court feels that no, now the case has to be reopened or restart, then it can also do that. Okay. So if the official stated, if the offences stated in the charge is altered or changed, one for the prosecution for which the previous sanction is required, the case shall not be proceeded until the sanction is obtained. So for example, if any charge has been altered in which the sanction is required, sanction means consent, a kind of, the case shall not be proceeded until those sanction is obtained, unless sanction has already been obtained from the prosecution on the same fact as those has been altered or changed. Now section 240. So where a charge is altered or added by the court after the commencement of the trial, the prosecutor and accused shall be allowed, underline, to recall or summon and examine the reference of such alteration or addition any witness who have been examined, unless the court, for the reasons to be recorded in writing, considers that the prosecutor or the accused, as the case may be, desires to recall or re-examine such witnesses for the purpose of vexation or delay for defeating the end of justice. For example, charges are altered. For example, first the charge for you was only kidnapping, but now the charge has been altered, and during the trial it was found that the girl whom you kidnapped was a minor girl. So in that case, what will happen? The charge will be altered. There is a different charge for kidnapping a minor girl. Now what the defense will do? They will tell that no, we again want to examine the witness because the charge has been altered. So they have under this provision they will recall means calling again all the evidences, all the witnesses who have already been examined. Okay, any doubt?
No, ma'am.
Now next topic is joinder of charge. This is again also very important. So according to